Dear friends, I welcome each one of you on behalf of Advocate on Record Aspirants Academy to the 13th lecture series. What is the topic for today? We are going to discuss about Article 134 of the Constitution of India, which deals with criminal appellate jurisdiction of the Supreme Court. Due to paucity of time, we would be covering just overall view about Article 134 of the Constitution of India today, and we will be seeing it in detail in the upcoming sessions. First and foremost, before starting or going into the topic, let us remember our forefathers, founding fathers of the Constitution of India, and the preamble, which is the spirit and soul of the Constitution. I request each one of you to recite the preamble along with me. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Dear friends, I request each one of you make this preamble as a part of our life and how to achieve these goals embedded in the Constitution. That is most important. Now, going into the topic, what is Article 134 of the Constitution of India? Let me tell you how to approach the topic first. Whenever we deal with a topic, we must ask questions ourselves. What is the purpose of this article? Lord Buddha asked about what is the purpose of his life? What is the reason for suffering, human suffering? Why people are in tears? What is the solution for their sufferings? He found out the solution that desire is the cause of all sorrow. Likewise, Socrates, the Greek philosopher, he asked all the young men and women in his country to ask questions to themselves as well as to the authorities. Why? What? Where? When? For what reasons? Therefore, we will not accept everything blindly. We will ask the questions to explore the unexplored path, to have an analytical mind, to weigh what is right, what is wrong, what is truth, what is false, what is dharma, what is adharma. So find out, ask questions. So taking guidance from Lord Buddha, Socrates, and even every day in our life as an advocate, when we stand before the highest court of the land, the Supreme Court asks us a question. What is the facts of the case? Why have you approached? What is the prayer? On what grounds you are challenging the impugned order? So everywhere we ask questions and then answer is given. Even when you go to canteen, you will ask what is there in your menu. What is fresh? You tell us. So everywhere we question to find out the answers. Right? So likewise, I have asked few questions with respect to this topic. What is Article 134? Where do I find the answers? It is there in the Constitution of India. Article 134 has got two clauses, dear friends. Now going into Article 134 clause 1, it says an appeal shall lie to the Supreme Court. An appeal shall lie to the Supreme Court from where? From any judgment, final order, or sentence. In which matter? In a criminal matter. Passed by whom? passed by the High Court within the territory of India. If the High Court, there is a condition. If the High Court, clause A, now we are moving on to Article 134, clause 1, subclause A, which says, if the High Court reverses the order of acquittal and sentencing him to death sentence. So, reversing the order of acquittal and then putting the person to death sentence. So, therefore, the Honorable High Court has acted as a first appellate court, because there is already an order of acquittal passed by the Sessions Court, and then the order passed by the High Court reversing the order of acquittal and sentencing him to death. There are two contradictions. The trial court says acquittal, High Court says convicted, sentenced him to death penalty. Two contradictions. One is on the left, extreme left, and extreme right. Therefore, it requires the interference of the Honorable Supreme Court. That is what Article 134, Clause 1A says. What is Article 134, Clause 1, Subclause B says? The Honorable High Court withdraws the trial which is pending before the court. Any case, it withdraws the case from any court subordinate to the High Court, and then it conducts the trial and then sentences him to death. Meaning thereby, my understanding is the Honorable High Court is acting as a trial court, because it has withdrawn the trial pending before any court subordinate to it. For example, it may be a Patiala court, Saket court, or Karkaduma court, where the trial is pending before that court. The High Court has withdrawn its case from such Sessions Court, and it is conducting its own trial and giving him a death sentence. Therefore, meaning thereby, the Honorable High Court is acting as a trial court. So, Article 134, Clause 1B, where the Honorable High Court acted as a trial court and sentenced him to death. That is second circumstances under which an appeal lies to the Supreme Court. Now, moving on to Article 134, Clause 1C. What does it deal with? It says a certificate has to be issued by the High Court, saying what? That it is a fit case to be decided by the Supreme Court. A certificate is to be issued by the High Court saying that it is a fit case to be decided by the Supreme Court. So, we have seen Article 134, Clause 1A also, B also, as well as C. Moving on to Article 134, Clause 2, which says Article 134, Clause 2 empowers the Parliament to empower the Honorable Supreme Court further powers. Therefore, they can make a law, a Parliament, it is giving a power to the Parliament to make a law to entrust the Honorable Supreme Court to exercise further powers. By virtue of this Article 134, Clause 2, there is an act was enacted, that is Supreme Court Extraordinary Criminal Appellate Jurisdiction Act 1970. So, enlargement of Criminal Appellate Jurisdiction Act 1970 was passed. What is the effect of this law? The effect of this law is when a High Court reverses the order of acquittal and sentences him either to death or to the life imprisonment or to the sentence minimum of less than 10 years. So, in such being the position, an appeal shall lie to the Supreme Court. So, what is the difference that we are finding? In Section 2 of this Act, Supreme Court Enlargement of Criminal Appellate Jurisdiction, further it says, when the High Court withdraws the trial pending before the subordinate court, and then it hears and imposes him either to death or to life or to punish him more than 10 years. So, under these situations, the appeal lie to the Supreme Court. So, it is enlargement of criminal appellate jurisdiction. Further, 379, Section 379 of CRPC, presently it is Article 420 of BNSS. In this, appeal lie to the Supreme Court. where it is again, it is in line with criminal appellate jurisdiction only, enlargement of Criminal Appellate Jurisdiction Act 1917. So therefore, dear friends, if we understand all this, what is the purpose for giving this? Because a person is either put to death or to life or to the imprisonment not less than 10 years. Therefore, it is heinous, grave. You are taking away the person's liberty. So therefore, it requires the interference of the Honorable Supreme Court. Hope it is clear. So now let us move on to the further topic, that is always the difference between a great, legendary, dynamic advocates and an ordinary advocate. What is the difference it makes? The ordinary advocate sees what is there. He'll just see it. Oh, it says about acquittal means acquittal. It says what is judgment, degree or final order or sentence. Whatever it is, they just see it as a plain language. But what about the legendary advocates? They see the world behind the word. They see the world behind the word. So what is that world I am talking about? Now let us talk about, if we say 134 clause 1 says that judgment also. It uses the key provisions: judgment, final order, sentence. So they dissect the terms. So let us ask ourselves this question: what is judgment? Judgment means a pronouncement by the competent court, either giving acquittal or convicting him. That is the judgment. What is final order? These are the key words used in or provided in Article 134 clause 1A. So what is the final order? Final order means which is not an interlocutory order. Final order must decide certain rights and liabilities of the parties. It is consents with the rights of the parties. If it is a mere interlocutory order, then it is not a final order. There are case laws which says when an accused asking for production of documents from the state or from the central government, if the court wants to ask for the summoning of the documents, the government says it is a privileged document, we will not provide it. Thereafter, the High Court says, no, you cannot claim that it is a privileged document. We will not allow you to take this plea, therefore provide those documents. If the aggrieved party, that is the state government, goes on appeal, the question lies before the Supreme Court is whether the order allowed for the production of the documents is an interlocutory order or a final order. If it is a final order, then High Court can issue the certificate. If it is an interlocutory order, the certificate issued by the Honorable High Court is not necessary at all. So what they have tested is the Honorable Supreme Court. I will be dealing with this case in the upcoming sessions. I am just giving an overall background. So the Honorable Supreme Court has held that it is only asking for the production of the documents to test whether the sanction provided by the central government, whether it has applied its mind or not applied its mind. So for production of the document means it is a very, very limited scope. It does not either convict the person nor accuse the person. So concerning only with the procedural aspects, it is an interlocutory order. It is not a final order. So what we have seen is judgment. We have seen either acquittal or convicting an accused. Final order means which is not an interlocutory order, which do not decide the rights and liabilities of the parties. Remaining things are left out. All the issues are left out. This is only the procedural aspect. Therefore, it is an interlocutory order. Right? What is sentence? Generally, for example, if there is a murder, either sentence can be a death sentence or a life imprisonment. Rarest of rare cases, the Honorable Supreme Court or the trial court can grant death sentence. Otherwise, it is a life sentence considering the aggravating circumstances and the mitigating circumstances. When the sentence is imposed, generally the Supreme Court do not interfere at all with the sentence, because it is a discretion power vested with the competent court to exercise their discretion. Generally they do not do it. Generally the Supreme Court do not interfere with the sentence unless and until the Supreme Court believes or feels that it is grave injustice has caused to the litigant or an accused, where the lesser punishment should be imposed but harsh punishment was given by the court. Under that circumstances, the Supreme Court will interfere. Where the trial court has imposed a lesser sentence but where it warrants the higher punishment, even in that situation also the Supreme Court will interfere. So this is what the judgment, final order, sentence. Now coming to order, Article 134 clause 1 subclause A, it talks about the acquittal, reversing the acquittal. What is the meaning of the acquittal? On one sense, on the one hand, we can understand, if a sessions court acquitted an accused, that means he is Mr. Clean, he can be released, he need not be, he is innocent. If that is the acquittal, then state government goes on appeal, and the High Court says reversing the acquittal and punishing him to death. Therefore, directly criminal appeal will lie, because Article 134 clause 1 subclause A is attracted. But the Honorable Supreme Court had an occasion to interpret the term what is acquittal. Very beautiful judgment. I will be dealing in the upcoming session in detail what is the acquittal. In that case, the Honorable Supreme Court has held acquittal means it's not complete acquittal. If a sessions court, they are giving an illustration. If the sessions court has, when a accused is charged under the for the offence of murder 302 and he is being tried for 302, but the sessions court converts from 302 to 304. So reducing, therefore meaning thereby they are acquitting the person, they are acquitting the accused from the charge of 302 and imposing the lesser punishment under 304. When state government goes on appeal, they feel that no, he must be found guilty under 302, therefore harsh punishment should be given. The sessions court has given only the lesser punishment and sessions court has committed erroneous because of reducing from 302 to 304. Now state government is going on appeal. There the Honorable High Court reversing the lesser, reversing the charge under 304 and they are invoking 302, that he has committed 302. Meaning thereby he is found guilty under 302 and the High Court imposing the death sentence. So on one hand, the sessions court convicting him under 304, acquitting him under 302. On appeal, the Honorable High Court convicting him under 302. Therefore, it means reversing the acquittal. So, acquittal means it is not complete acquittal. You can also bring this interpretation also when there is a lesser punishment is given, when it is enhanced, that also becomes within the meaning of acquittal. Now you understand 134 clause 1b, that is withdrawing the trial and conducting the trial by the High Court and then putting him to death sentence. Now with respect to the certificate is concerned, Article 134 clause 1c, certificate is very, very important, because it is not as a matter of practice the Honorable High Court should issue a certificate. The High Court should ask itself a question, whether is it a fit case to issue a certificate. How do they ask that it is a fit case? So it is a discretion vested with the Honorable High Court. What sort of discretion? It is a judicial discretion vested with the High Court. And how to find out whether is it a fit case to issue the certificate or not? So the Honorable High Court will ask itself the question, whether that particular case involves a substantial question of law. It is not mere question of law. It is a substantial question of law. That is the first question it will ask. The second question, whether the substantial question of law involves general importance. Number 2. Number 3, whether there is a gross violation of principles of natural justice, whether he was sentenced to death without hearing him. So it goes to the root of the matter. So therefore, under that circumstances, the High Court will issue a certificate certifying that this is a fit case to be decided by the Supreme Court. And then when there is judgment passed by the Honorable High Court based on the unsound principles, there is a established principles of law, but ignoring the established principles of law, giving a certain finding, therefore certificate is necessary. So certificate, where the Honorable High Court issues a certificate believing that it is a fit case to be decided by the Honorable Supreme Court, it is a judicial discretion vested with the Honorable High Court. Therefore, Honorable High Court should ask all these tests, they are put to test, whether is it against the settled principle of law. When it involves only the question of fact, whether certificate is necessary, not at all. The Honorable Supreme Court will not go into the question of fact, dear friends. So therefore, certificate will not be issued. I repeat, substantial question of law, substantial question of law of general importance, or when there is a gross violation of the principles of natural justice, or the Honorable High Court has gone against the well-established procedure of law. So under these circumstances, the Honorable High Court will issue the certificate saying that it is a fit case to be decided by the Honorable Supreme Court. So with this, dear friends, I have given an overall view about Article 134. The message of this seminar is, please ask questions to yourself. When there is a constitution, when there is a particular provision, why? Why they have put shall instead of may? Why they have put that this is the empowering the parliament to make a law? What is the need? Reason is, the need is a person cannot be put to life sentence or more than 10 years, that has to be heard by the Honorable Supreme Court. So that is why the Supreme Court enlargement of criminal appellate jurisdiction has come. Why do we need to recite the preamble? We need to recite the preamble because the entire constitution's soul is embedded in the preamble, spirit of the constitution. Being a lawyer, being an advocate on record, being a practitioner in the highest court of the land, are we not supposed to know what is the meaning of the preamble? What is there in the preamble? How can we achieve these goals in the preamble? So we must ask ourselves this question, dear friends. Why are we here? Why are we practicing in the Supreme Court? We have left our roots. We may be from various places. Maybe from state of UP, state of Bihar, state of AP. Why? Because we want to excel in the field of law. We should always ask these questions. What is the purpose of me being in Delhi? Though the situations, the weather, conditions, everything is bad, pollution, but still we are here. Why? Because we are for this bigger purpose, the important purpose. What is the purpose? We have to uplift ourselves. In this process, we have to uplift our family, our litigants, nation. Therefore, ultimately what is there in the preamble is realized by the citizens of this country. We the people of India, it is not we the people of advocates or we the people of parliamentarians, we the people of India. Therefore, the entire constitution is vested with the people of India, that is you and me. It is an individual responsibility. We cannot shy away from the responsibility. It is an individual responsibility assuring the dignity of everyone, and we have drafted it and we have given to ourselves. So every Indian must have the responsibility. How do we praise our mother India? By reciting Janagana Mana. In the same manner, we have to recite the preamble. Therefore, our legendary father, living father, dynamic father will save this nation. Thank you so much, dear friends. Thank you so much. Yes. We will deal with it later. Yes.